Hello everyone. Today we are going to discuss Panchayats and the PISA Act, which is the Panchayat extension in the scheduled areas. This article will enable the students to understand the various aspects of the PISA Act, the features of the PISA Act, the challenges that the Act faced in its implementation throughout India, and also the ways to empower the Gram Sabhas, which are an important institution so far as the PISA Act is concerned. To start with, local self-government, interpreted as devolution of power and function of the government departments by the creation of Panchayati Raj institutions as a national framework of governance commenced with the passage of the 73rd Amendment Act. The states made suitable amendments to existing panchayat laws where they existed and enacted legislation in accordance with the 73rd Amendment Act where they did not exist. The devolution of powers and responsibilities to the Panchayati Raj institutions were neither uniform nor at the same pace, but progressed steadily. The scheduled areas were exempted from the application of the 73rd Amendment Act, for which the Parliament enacted a separate law, Panchayat extension to the scheduled areas in 1996. PISA provisions were incorporated through amendments to the state Panchayat laws. The provisions of the Panchayat extension to the scheduled areas is an important and key piece of legislation to empower the tribal communities. The PISA Act is called a constitution within a constitution. The Act aims at devolving governance to panchayats and gram sabhas in Schedule 5 areas for mainstreaming tribal development. The PISA Act provides the constitutional framework to preserve tribal self-identity, culture, customary laws, and to protect their traditional way of life. It also as when it came into existence on 24th of December 1996 in 10 states in India with predominant tribal population, namely Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Orissa, Rajasthan, and Telangana. The fundamental spirit of PISA Act for tribal areas under Schedule 5 is that rather than delegation, it devolves power and authority directly to Gram Sabhas and Panchayats. Hence, it carves out a path for participatory democracy. The provision under this Act calls for all legislation in respect of the Panchayats in Schedule 5 areas to be in conformity with the customary law, social and religious practices, and traditional management practices of the tribal communities and their resources. It also directs the state governments to endow power and authority to make Gram Sabhas and Panchayats functions as institutions of local self-governance, specifically on matters of enforcing prohibition of sale and consumption of intoxicants, ownership of minor forest produce, power to prevent alienation of land, and restoration of unlawfully alienated land, management of village markets, control over money lending, etc. Hence, PISA Act has been an attempt to provide dignity to the tribal community and bring them into the mainstream of development process through their self-governance. Now we come to a brief history of local government in India. India has a long and strong tradition of democratic institutions from ancient times. Grounded in the social and political organization of the local habitations, over time these institutions have transformed but nevertheless socially, politically recognized as central to governance despite their shortcomings in terms of a variety of discriminations that exist within society, such as caste and gender. A classic instance of such recording is by Macliffe, who recorded that the village communities are little republics, having nearly everything they can want within themselves. Dynasties. After dynasties tumble down, revolution succeeds revolution, but the village community remains the same. This union of village communities, each one forming a separate little state in itself, has contributed more than any other cause to the preservation of the peoples of India and the enjoyment of freedom and independence. These sabhas or assemblies evolved into panchayats, an assembly of 5 elders, which then became center of authority for dispensation of justice and resolution of local disputes. They interfaced with the higher authorities, local chieftains to Maharajas, separated in power and authority. Village functioned as self-governing units or little republics. This continued till major changes and restructuring of the administrative hierarchy began with the British colonialism. The Government of India Act 1919 introduced local self-governing institutions with popular mandate and control over local affairs. As a result, a number of provinces and princely states enacted laws. Village Panchayats Acts in Madras, Bombay, Central Provinces, and Uttar Pradesh in 1920. Self-Government Act in Bengal in 1919, in Bihar in 1920, in Assam in 1925, and the Panchayat Act in Punjab in 1922. Later, the Government of India Act 1935 introduced provincial autonomy and elected governments. Panchayati Raj did not find a place into the draft constitution. The debate whether the village is a sink of localism, a den of ignorance, narrow-mindedness and communalism, or whether Indian independence must begin at the bottom, ensuring that every village has to be self-sustained and capable of managing its affairs, resulted in the formulation of Article 40 in the directive principles of the state policy of the Constitution, which was not enforceable. Article 40 states that the state shall take steps to organize village panchayats and endow them with such power and authority as may be necessary to enable them to function as units of self-governance. Over the decades, since the decadent feudal landlordism with its oppressive exploitation began crumbling, both these viewpoints seem to have progressively moved upward to finally converge with Panchayat extension to the Scheduled Areas Act in 1996, where relatively the formal structures were yet to penetrate or were weak. The feudal structures were at its weak, and self-governance in an egalitarian tradition continued to persist. The Balwant Rai Mehta Committee, constituted to evaluate the community development and national extension service programs, in their report of 24th November 1957, recommended the transfer of decision-making powers from the state to the village panchayats and the establishment of statutory elected local bodies and devolution of all necessary powers, authority, and resources to them. The National Development Council on 12 January 1958 approved this proposal to extend democracy to the grassroots and people's participation in all governmental processes and development. Rajasthan and Andhra Pradesh took the lead in creating new three-tier system in 1959. A fresh lease of life was brought by the West Bengal Panchayati Raj Act of 1973. The Ashok Mehta Committee reviewed the existing system in states and union territories in 1977. They proposed the substitution of the three-tier structure with a two-tier structure consisting of Mandal Panchayat and Zilla Parishads, with the district collector exercising regulatory functions and bringing suitable constitutional amendments. The Zilla Parishad were to be the power center below the state. West Bengal in 1978, followed by Andhra Pradesh, Karnataka, and Kerala, adopted this model. The G.V.K. Rao Committee of 1985 recommended a three-tier structure and the appointment of a District Development Commission as the chief executive of the Zilla Parishad. The L.M. Sanghvi Committee of 1986 favored a constitutional sanction for the Panchayati Raj institutions by introducing a new chapter in the Constitution. This resulted in the Constitution of the 64th Amendment Bill of 1989, proposing insertion of Article 243 in the Constitution, making the three-tier system mandatory in all states. However, this and the 65th Amendment Bill to endow urban local bodies, passed in the Lok Sabha on 13th October 1989, could not get through the Rajya Sabha. A combined bill was introduced in 1990 as the Constitution's 74th Amendment Bill could not get through as the government changed. Finally, the 73rd Constitutional Amendment Act and the 74th Nagarpalika Constitutional Amendment Act were passed on 22nd and 23rd December 1992 respectively. This was ratified by the all serving state assemblies except West Bengal. The acts were notified on 24th April 1993 and 1st June 1993 respectively. Two new parts were added to the Constitution, namely Part 9, titled The Panchayats, and Part 9A, The Municipalities. The acts transferred 29 subjects to the Panchayats and 18 to the municipalities. Within a year of the act coming into force, the states were to make suitable modification to their laws to be in conformity with the amendments. However, the 73rd Amendment Act had clear injunctions to exclude the 5th and the 6th scheduled areas, besides the state of Nagaland, Meghalaya, and Mizoram, the hill areas of Manipur, and the Gorkha Hill Council area, for which the parliament was to make separate enactments. For the tribal-dominated states that do not fall under the 5th and the 6th schedule, these were special constitutional protections with greater autonomy in the states of Nagaland, Article 371A, and Mizoram, Article 371G. The national frame was adopted for Arunachal Pradesh, Sikkim, Manipur, excluding hill areas. Article 371C provides for a special committee of the Manipur Assembly to consider matters related to the hill areas. The non-council areas of Assam and Tripura, as well as the areas falling outside the scheduled areas in the states having scheduled areas. The same was also the case of the remaining states which did not come under any of these constitutional provisions, namely Kerala, Karnataka, Tamil Nadu, West Bengal, Uttar Pradesh, Uttaranchal, and Goa, as well as the island regions of Andaman and Nicobar Islands and Lakshadweep. 5th scheduled areas and the 6th scheduled areas were also explicitly exempted from the application of 74th Amendment Act, for which the Parliament may enact separate laws extending its provision. Now we come to the PISA Act, which is Panchayat extension to the scheduled areas and its significance. The tribal people live in hilly areas or regions and the scheduled areas far from the mainstream population. Forest is their natural habitat and their way of environmental protection is adorable. The tribal people are rich in morals, social values, cultural and linguistic practices. They have a self-sustained economy and practices self-governance. In fact, their dispute resolution mechanism among the tribals are an example of their self-governance. The PISA Act aims to bring the tribal population into the mainstream society through enabling of their self-governance to be an intrinsic part of their development process. This has been aimed by giving special powers to the Gram Sabhas. The Act protects tribal people from moneylenders, land alienation, and provides them ownership of minor forest produce, minor water bodies, and community assets. However, the implementation of this act has been facing challenges because the tribal communities are yet to acquire social, economic, and political well being. As 25 years have passed since the enactment of the PISA Act, while many advancements in the livelihood of tribal communities have been made possible from the provisions of the Act, it is observed that there are still many challenging gaps that are needed to be bridged in order to achieve the intended goals towards fulfillment of the aspirations of the tribal communities. Now we come to the salient features of the PISA Act. To start with, powers exclusive to Gram Sabha. Now every village shall have its own Gram Sabhas. A village may consist of one or more habitation or hamlets comprising a community and managing its affairs in accordance with traditions and customs. Gram Sabha is competent to safeguard and preserve the traditions and customs of the people and their cultural identity, community resources, and customary mode of dispute resolution. The Gram Sabhas have mandatory executive functions. Firstly, approve plans, programs, and projects for social and economic development of the tribal communities, identify persons as beneficiaries under poverty alleviation programs and other programs, issue a certificate of utilization of funds by the panchayats for the plans, programs, and various projects, powers exclusive to Gram Panchayats on Sabhas at appropriate level are right to mandatory consultation in land acquisition, resettlement, and rehabilitation of displaced person. Panchayats at an appropriate level is entrusted with planning and management of minor water bodies. Mandatory recommendation by Gram Sabha or Panchayats at appropriate level for prospective licenses or lease, concession for mines and minerals. Powers are also endowed to Gram Sabha and Panchayats at appropriate level to regulate sale and consumption of intoxicants, ownership of minor forest produce, prevent land alienation and restore alienated land, control over institutions and functionaries in social sector, local plans, including tribal subplans and resources. The status of implementation of PISA in the 10 PISA states has been observed to have many variations. The study on the status of Panchayat extension to scheduled areas in Andhra Pradesh, Gujarat, Chhattisgarh, Jharkhand, and Orissa, conducted by PR Foundation in 2010, has emphasized that the reasons for poor implementation of the PISA are complex and multi-pronged. PISA Act has specifically empowered Gram Sabhas to approve plans, programs, and projects, as well as to identify beneficiaries under poverty alleviation programs. However, certain dilution of such provisions is also seen. Like, for example, the state of Madhya Pradesh has added a rider to this provision as subject to the rules which the state government may make in this behalf and subject to the general and special orders as may be issued by the state government from time to time. The PISA Act prescribes that prior consultation with the Gram Sabhas or the panchayats at appropriate level before acquiring of land for development of projects and before resettling and rehabilitation of persons affected by such projects are mandatory. However, the Act further adds a clause of giving option to states to devolve power either to Gram Sabhas or to the panchayats at appropriate level, which may be the lowest level or the intermediate level or the apex level. Hence, many variations on this account are being noticed. In the state acts of Andhra Pradesh and Gujarat, these powers have been delegated to Mandal Panchayats and Taluka Panchayats respectively and not to the Gram Sabha. The Orissa Panchayat Act has given this responsibility to Zilla Parishads or Zilla Panchayats. Himachal Pradesh and Maharashtra Panchayat Acts have given this change or this charge to the Gram Sabhas. The Madhya Pradesh Act does not specify it in any clear terms except saying that the Gram Sabhas will manage natural resources including land. The Rajasthan Ordinance has given this power to the Gram Sabha or Panchayati Raj institutions as may be prescribed. Hence, there is a lack of uniform practice or pattern emerging from the provisions made by the concerned states. PISA Act has also made provisions that planning and management of minor water bodies be handled by the panchayats at the appropriate level in scheduled areas. In other words, this function was not to be entrusted to the Gram Sabhas. Andhra Pradesh Panchayat Act has assigned this function to the Gram Panchayat or Mandal Panchayat, as the case may be. Gujarat Panchayat Act assigns this task to Taluka Panchayat. Orissa Panchayat Act has given this power to Zilla Parishads. Himachal Pradesh and Maharashtra Act have no exact specification on this matter. Madhya Pradesh state has, however, clearly specified that the Gram Panchayat would take decisions in matters relating to planning and management of minor water bodies only after consultation with the Gram Sabhas. Section 4M of the PISA Act, while prescribing that while endowing the panchayats with power and authority to function as units of local self-government, the state legislature shall ensure that the panchayats at appropriate level and the Gram Sabhas is endowed with specific power to deal with various issues as faced by the tribal communities. Issues such as in sale and purchase of intoxicants, land alienation, rights over minor forest produce, etc. All these issues need to be sorted and consulted in accordance with the powers and authority of the Gram Sabha. The state have implemented these provisions in varying degrees. For example, Andhra Pradesh and Himachal Pradesh Panchayat Act have given the power to enforce prohibition to the Gram Sabha or the Gram Panchayats as the case may be, while the Gujarat Panchayat Act has given this power to the intermediate tier of the Panchayat Raj system and not to the Gram Sabha. Maharashtra and Orissa Panchayat Act have given this power to the Gram Sabha, whereas Madhya Pradesh Panchayat Act does not make any mention about this. Now we come to the various challenges in the implementation of the PISA Act. Firstly, the lack of awareness about PISA amongst tribal community. Although PISA has come into existence in 1996, it has been observed that local tribal community of the 5th scheduled areas has very limited understanding of law and powers extended to them under PISA. Secondly, limited autonomy of the Gram Sabha and panchayats at the lower level. In many cases, it is observed that the Gram Sabhas are influenced by non-tribal individuals. Also, overseeing the implementation of the Act by the functionaries who may not have proper understanding of tribal culture. There exists a knowledge gap in understanding the tribal culture and their way of living by some of the functionaries, leading to greater alienation between the tribal and the non-tribal population. Also, lack of institutional mechanisms and enabling ecosystem, such as adequate capacity, proper access to information, etc., for empowering Gram Sabhas as centers of self-governance. There is also the issue of non-compliance or violations of provisions under PISA. Another problem which the implementation process have faced is a gap in adoption of PISA in letter and spirit. The presence of committees and forums operating parallel to the PISA Gram Sabhas. The Gram Sabhas to be conducted under PISA often see low turnouts and participations due to the presence of parallel customary forums and other communities. The efforts towards creation of awareness and publicity for the meeting of Gram Sabha also needs to be improved. Creation of necessary position of vice president or secretaries for the individual Gram Sabhas and take action to fill up those positions through nominations or elections. Issuance of utilization certificate by Gram Sabhas to be made mandatory for all financial allocations and releases. Panchayat finances may be further decentralized towards creation of independent account for each Gram Sabha with full financial autonomy for their operations, including control over the revenues generated out of giving licenses for the exploration of minor water bodies and minor mineral resources. Provisions of adequate logistics, like the space in the panchayat buildings, towards organization of Gram Sabha meetings, etc. Formation and efficient functioning of various subcommittees for various enabling provisions of PISA, like control over minor water bodies, forest produce, mining and mineral right, control over intoxicants, etc., under the overall supervision of the Gram Sabhas. Suitable resolution mechanism may be established to harmonize between the state government official processes in conflict with PISA Gram Sabha decisions. Also, the entire restoration of rights over minor forest produce in the scheduled areas to the Gram Sabhas or tribal beneficiaries as envisaged in the PISA Act by removing all intermediaries of contrary government notifications and also facilitating value addition in the same. Also, the mechanism for unburdening of different costs charged by the Forest Department officials for assisting in commercialization of minor forest produce on the PISA Gram Sabhas towards provision of full benefit to the tribals. All these enabling provisions are important for the proper implementation of the PISA Act. If we can look into these various ways to empower the Gram Sabhas, only then the PISA or the Panchayat extension to the scheduled areas can be brought into its full implementation scope in the tribal areas and lead to the better integration of the tribal community with the mainstream population. With this, we come to the end of our discussion. Thank you.